morning. Welcome in. I'm just going to wait for you guys to tune in. Welcome. I can't believe we are on the last week in April. This year is flying. If you are on YouTube or Facebook and you can hear or see me, let me know in the comments. I'm not sure if I went on live there. I can see you guys on Instagram. Welcome. Good morning. If this is your first time tuning in, thank you for joining. Welcome. Let me know where you're tuning in from. My name is Aisha Chidole, and I'm an immigration lawyer. I represent clients all over the United States with their immigration matters. We handle family-based cases. Marriage, children, fiancé visas, consular processing. We also handle humanitarian-based cases like VAWA for victims of abuse, removal of conditions, regular ones and the ones with waivers, trafficking visas, victims of a serious crime visas, special juvenile immigrant visas. We also handle removal cases and, detention cases as well. So definitely schedule a consultation if you would like assistance with your case, or share this with a friend or a family member who might need help. Let me put my number right here in here, and then we can just jump right into questions. So feel free to ask your questions. I hope everybody had a great week or weekend. WhatsApp, just give me a second, guys. Let me put in my phone number, 8751. Okay. So let's pin that. First time from Maryland. I'm trying to get my fiance from Tanzania over here by summer of 2028. Well, welcome. Hopefully your dreams do come true and you can get them in here. Good morning. Will you be put in removal if your T visa is denied? Any case you file right now, if it's denied, there is a very good chance that you'll be sent to removal proceedings. If you are sent to removal proceedings, you'll be looking at whatever else that you'll be eligible to plead. Sometimes you can plead certain cases in removal proceedings, but without knowing your immigration history, I will not be able to answer that. Without knowing whether or not you have a T visa or you're just asking a speculative questions, I can't answer that. But any case, whether it's a marriage-based case, whether it's any case you file right now, if you are not in status at the time of your denial, you have a good chance of being recommended for removal proceedings. Removal proceedings is when you go to immigration court and you receive something called an NTA, which is a notice to appear in front of an immigration judge. That is also another opportunity for you to plead your case. So all of this will depend on what other available bases do you have to plead. For some people, they're going to have what we call 10-year non-LPR cancellation, meaning that they're not green card holders, but they've been in the country for 10 years. Sorry, guys, I have really bad allergies. So some people, might be eligible for VAWA cancellation. Some people might be eligible based on a family member that can petition for them. So there are many things that would need to be reviewed to see if there's anything else that you can plea on in removal proceedings, basically. Okay. How do people usually explain their overstay? They explain exactly how their overstay is, So, if I don't really know what that question means. Like every single person has a different reason why they overstayed. So you explain it why you chose to overstay. You don't want to show immigrant intent if you didn't plan to overstay. For a lot of people, they come here and then when they're here, for whatever reason, they choose to overstay, or I was here and then, I've had clients say, I was here and my granddad was by himself and, my mom just asked me to stay back to help him with his mobility issues and then I stayed. For others, having an abusive marriage back wherever they're from, they came to visit while they were here, they got some support and they chose to. So there are different reasons. Like I can't tell you the reason why you chose to overstay. You should know the reason why you chose to overstay. Now, if you're married to a U.S. citizen, Generally, they'll forgive an overstay, but at the same time, you don't want to show immigrant intent that that was literally your goal when you came into the United States. Okay. Hi, Soniston. How are you? Um, Joanna says, "Good morning. What happens if you have an adjustment of status in the process and you get an NTA?" I talked about this extensively earlier this month because I told you guys about my clients that we got that we had filed for an I-485, and he got an NTA because of a denied case that he filed before he came to us, because something was wrong with that filing anyway. We ended up getting his green card approved at USCIS, and then we just went to the court and asked them to terminate the proceedings, and they terminated the proceedings. So he's a 10-year green card holder. Now, it varies depending on who your officer is. Some officers will put the case on administrative hold, the 485, and tell you to go finish it off in court. So the way that you finish it off in court is if your I-130 is approved, the judge will typically wait for your I-130 to be approved, and then they can close the case. Sometimes they will ask you to just do the marriage-based case, because I'm assuming you have a marriage-based case. That's why you typed AOS. Sometimes they'll ask you to just do it in court, like just do everything in court. So, really, the answer depends on who it is that is reviewing your case and their preference of how they do things. You're going to have a judge. You're going to have some judges that sometimes will approve something and say, okay, go back to USCIS and finish it. And sometimes you're going to have a judge that's more tough and says, no, you fee into the removal court and just do it here in the removal court. So it's one of those things, again, that there's no predictable answer because everyone is different. But if you do have an adjustment of status, so whatever that base is that you have, you still have the basis in court. So you can still plead it in court and prove that you're eligible for it in court. Dwala says, how do I speak with you or Attorney Stacy? I'm one of your clients. You speak with us by scheduling a consultation, calling the office to schedule a consultation with one of us. Our plan is K1, building a bank account there and marriage at the embassy before her flight here, returning with me after my third or fourth visit. I don't know if this is a continuation to a particular question. So if there was a question, you can let me know. What does the extension of a prima facie mean, and does it keep getting extended? Every VAWA case if you file for VAWA and you're eligible for a prima facie determination letter, you'll get a 1-year prima facie determination letter. After the 1-year prima facie determination letter, then you start getting renewals every 6 months until they make a decision on your case. A prima facie determination letter basically is saying that you've met the basic standards of review of your VAWA case. It means also that we're going to review your case in more in-depth later on, but for now, we're going to give you this prima facie to allow you to have certain benefits, which vary depending on your state. In some states, it offers them the ability to get a driver's license. It offers them the ability to get affordable housing. And then some schools will also accept it for financial aid and to enroll you as a student, you or your children, if your children are listed on there. I have an I-130 approved, and then I have an adjustment of status interview tomorrow. Can they ask about my asylum case that I already withdrew, marriage-based U.S. citizen? Yes, they will ask about it most likely. They almost always ask about it, so just prepare to talk about it. I mean, they're not going to go as in-depth as in an asylum interview, but generally they do ask, oh, what did you file asylum on the basis of? Why did you withdraw? You just want to make sure that your lawyer or whoever it is reminds them that, this interview is for your marriage-based case, and that case has been withdrawn, so it wasn't adjudicated, and you don't want to adjudicate it today. So make sure that you're able to articulate that or have your lawyer articulate that. What does it mean if you get this response? Our records show that your case is pending adjudication. What does that mean after completing the interview since May 14th, 2025? It means that they haven't made a decision in your case. Adjudication means they've decided your case. They've not made a decision in your case and your case is pending. But if your case was May 14th, 2025, and you had an interview and they haven't made a decision in your case. I mean, I don't know if you're from one of the 39 countries. Obviously, if you're one of the 39 countries, there's kind of like a delayed review of those cases. But before they started a delayed review in January, that still puts your case out about 7 months, which to me is usually a concern. Anything after 6 months means that basically there's a very high likelihood that you're going through a fraud investigation. So that is what I think might be happening with you. I've started the process for my husband. He's in Jamaica. Can you help speed up the process? Unfortunately, not right now. Jamaica has is part of the 75 country pause outside of the United States. So if he's consular processing from outside the United States for a spousal immigrant visa, he's going to be facing a pause. His case will not be able to be sped up. How long does the process for marrying a permanent resident from Peru take? I haven't started the process yet. So you're not a U.S. citizen. You want to marry a permanent resident from Peru. Do you mean that he's a permanent resident from Peru or he's a permanent resident to the United States? Your question is not clear, Iris, and you also haven't clarified whether or not you live in the United States or you're outside of the United States. Are you in the United States? If you are, do you have a valid visa, meaning that you have not overstayed your entry under your I-94? So I would need all of those things to be able to answer. Domia on Facebook says, if you file for VAWA by sending only an I-360, when is the best time to file for the 485 and 765? The best time is when you're eligible. So if you were eligible to send it when you filed the I-360, you should have sent it then. Right now, it depends. Why didn't you send it? So that's the first question. Are you in removal proceedings? If you're not in removal proceedings and you didn't send it, maybe because you were married to an LPR, a green card holder, you want to check the date on your receipt. Right now, the April and May visa bulletins are current. So if you were married to a green card holder when you submitted your VAWA anytime and received your receipt anytime before April of 2026, or obviously May, which is not here, you can file your adjustment of status. But again, this is going based on not knowing anything about your case and just assuming that you just have a case that you just either didn't file it because you were married to an LPR or you just forgot to file it, and I'm also assuming that you're not in removal proceedings. So again, a lot of these questions you guys ask, knowing a bit more about you and your case is helpful. And the only way I can do that is through a consultation. You gotta just schedule consultations. All this guesswork that you guys sometimes ask and go into all these nuanced questions, you'll make your life easier by scheduling a consultation. Any new update about the ban? I'm Nigerian based in the UK, waiting for an interview appointment for EB2. Sorry, no new news yet on the ban. I'm married and I'm going on 3 years. I have a baby. We're living together with family, but now I'm trying to quit in my paperwork. To put in, is that what you're trying to say? I'm not sure I understand your question, Best Darky. What are you like? What is the situation? Like, are you an overstay? Are you in America? Like, who you're married to? Again, if you guys want me to answer like specific questions, I have to be a bit more detailed in there. I got my 2-year green card in August of 2025, and now my wife wants to give me a divorce. What should I do? Divorce is very personal, so I can't really tell you what to do about the divorce. You can't force someone to stay married. That said, you can always file a waiver based on divorce. So like if the divorce is finalized, you want to immediately submit a an amendment and request for a waiver based on the waiver requirements to USCIS, letting them know that you did have a good faith marriage, but you and your spouse are divorced. Speaking of which, we got a green card today in the office, which was actually based on something similar to yours, but yours was based on ours was based on extreme cruelty, and this client didn't end up getting interviewed. What ended up happening is she filed a joint filing. The spouse became extremely abusive, and then we filed for a waiver based on abuse. So we got this today, but you basically need to amend your case. That's what you need to do once a divorce happens. My prima facie expired March 14th, and I haven't gotten a renewal. Official VASH, that's okay. Prima facies are notoriously late for most people, 2, 3, 4 months late, but I'm sure it will be in the mail, you know. Why are they approving work permits under asylum, even if that person's from 39 country pause? And not for people under 485. Well, as I'm sure you know, a couple of weeks ago, they lifted the hold on asylum cases. The other people are still under adjudicative hold-ish. I say hold-ish because, again, we've started to see some movement. But until I have an actual approval in my hands, I can't fully tell you that they've lifted it. Like, when I mean some movement, people that were canceled for interviews are now being rescheduled. I have actually a bunch of interviews this week, with some of them from those countries, some not from those countries. So depending on how it goes, I will let you know. I refiled my work authorization since 2024 and no response. I'm a VAWA petitioner. Sam, that is a really long time since 2024, because we're in 2026, which would mean that you filed it 2 years ago. I would want to know and see your submission, what you were submitting, where you submitted it to, and what the basis was of your 765. How long before you get a decision made on your I-751, removal of condition, green card? Honestly, we're seeing a really long time, which is why they give you 48-month extension. We're seeing a lot of people not get decisions for at least 2 to 3 years. If you are eligible for citizenship and you have a really strong I-751 case, then by all means file for removal, file for naturalization. That would be a way to get it done quicker, where they both, where both decisions are being made at the same time. Okay. Okay. Thank you for your continued support. My first prima facie expired last February. I'm from the first list of banned countries. I've not received a renewal of the prima facie yet. Do you think that is normal? I just answered this question for someone else. That is normal. I can 100% affirmatively confirm that they are issuing prima facies to people from the banned countries. I can 100% confirm that, because we have hundreds of those that we get, because I do track and monitor this thing so that I can be able to update my clients and consult where immigration is. So for a fact, they are approving those. That said, it was February 1st. I just mentioned they're notoriously late, 2 to 3 months late for most people. So you're still in a normal window. You will get your removal, your prima facie. A lot of you are typing and then you just cut off, and so I can't. I'm not answering those questions because I need a full sentence, like, to understand what it is that you're asking. I filed for VAWA next month. I filed for VAWA. Next month will make it 4 years. No RFE. I only got a notice for biometrics last month. After my biometrics was previously said, they would use my previous one. Oh my gosh, your question just disappeared. I'm so sorry. Your question just disappeared to the one I was reading, so I can't even finish it. Oh. What is the likelihood of an asylum case being granted when I seek your services? We don't take asylum cases, so that's not something we'll be able to assist you with, unfortunately. Let me see if I can go back to that one. I can't find that one again. I'm living in the US, getting married to a green card holder. We live together and share a child together. What is the timeline for work authorization? The first question you should be asking is, are you eligible to file for adjustment of status? Most times, if you are in overstay, meaning you're living in the United States and you have overstayed your I-94 entry, you're not eligible for an adjustment of status. And if you're not eligible for an adjustment of status, you're not eligible for a work permit or even a travel permit. So for you, Alicia Bird, the first question is, when did you enter into the United States, and what does your I-94 say is the last date for you to be in the United States? If your application is not filed before that last day, meaning your adjustment of status and your work permit, you're not eligible to get one. Now, if you entered into the United States in January, for instance, and your I-94 doesn't expire till June, for instance, in the month of April, the visas are current, so you can apply right now because you're currently in status. Remember also, you cannot work under the table. You cannot violate any of your non-immigrant status in order to file under an LPR. It's not the same with the US citizen. So if that applies to you, then you can file. You can file in May, but you want to file before whatever date it says in June. So I'm just giving this as a hypothetical because I don't really know your date. But that's how you kind of look at it. Okay, this person says, sorry, I'm from Brazil. I live in the United States with a valid visa. My spouse is from Peru and has a green card. He has been here for 2 years. I was wondering how long the process is taking if we get married. Again, you have a valid visa, but are you in a current status? Meaning, is your I-94 current? Meaning you've just entered the US and you're still within the normal 6-month entry. Some people get only 2 months, some people get only 3 months. I don't know what yours is, but I'm just going with what majority of the people get in. If the answer is yes, you're still within normal status, the process will take a little longer for you because you're a green card holder, so you still have to wait. They're still processing cases from 2024, but they will give you your work permit and travel permit while your case is pending. Now, if you are married to a US citizen and you're filing a marriage-based case, right now we are seeing a really, really, really fast interview timeline. You know, I did a few prep sessions last week. Well, I think the quickest one I saw was that we submitted in February. We're April 27th. That person's interview is in 2 weeks. So that's literally 2 months later, like 2.5 months later. But a lot of the people that maybe we submitted in like October and September, all their interviews are in April. Like this is for a marriage-based case. So they're moving really, really quickly with that, maybe even at a slightly faster pace than a naturalization. Now, having said that, you really still need to have a really good marriage case because, you know, being interviewed doesn't mean you're going to be approved. Being interviewed means that you need to prove that you have a genuine marriage. So you really want to make sure, especially because they're moving really quickly, that you're not moving yourself quickly to deportation. You really want to make sure that you really have your ducks in a row. You really have solid good faith evidence, or continue to have it the minute you submit, because it is very likely that you could you could be scheduled for an interview and they're going to want to see more stuff. I remember my clients who we have this interview on the 30th, that's this week, and we submitted in February, and I joked and I said, you know, normally we would have extra good faith marriage evidence to take, but really we only have March's new statements because April is not even over, so we don't even have April statements to take. I gotta jump off, guys, but Schedule a consult if you have a specific question about your case. A lot of times you guys ask questions that are very difficult for me to answer because I don't have all the variables. Again, it is better to know truly about your own case and what you're eligible for than trying to do hypothetical. I'm asking for a friend, or can I ask a random question? Our number here is 407-995-6567. Or 40, well, you can send a WhatsApp to 404-333-8751. And I will talk to you guys later. Have a good day, everyone. Bye.